Right, thank you very much for joining us here on the JoyNews channel. So we know the verdict of the Supreme Court concerning the 2021 election petition now. Let's get to the campaign office of John Dramani Mahama, who was flag bearer of the NDC in the 2020 general elections, with the Supreme Court dismissing his petition as he addresses all of us.
It was the right thing to do. It is gratifying that the court proceedings were broadcast live and Ghanaians followed the hearings diligently. They understood what was happening, even if the legal terminologies were not always easy to grasp. Even though the petition to the Supreme Court stood in my name, it nonetheless represented the desire of an overwhelming number of Ghanaians, anxious for answers from the chairperson of the Electoral Commission as the returning officer of the December 2020 presidential elections. Ghanaians were hoping to hear her testify, and many are still baffled by the refusal of Mrs. Jean Mensah to be held to account by testifying in this case, unfortunately with the unanimous agreement of the justices of the Supreme Court. The vital part of the process to establish the truth and hold Mrs. Mensah accountable was blocked time and again by a protective cordon and firewall that I'm sure has confounded many Ghanaians. The refusal of this chairperson is in sharp contrast to the readiness with which Dr. Kwadwo Afari-Gyan, then chairman of the Electoral Commission, willingly testified in the 2013 election petition filed by then candidate Nana Akufo-Addo of the MPP. Speaking as a Ghanaian with no legal training, I believe that the refusal of the Electoral Commission chairperson to testify in this election petition leaves a very bad precedent for the future. I disagree with the suggestions of our justices that an election petition is akin to any other civil litigation, and therefore an EC chairperson whose functions go to the heart of our democracy can, by a legal sleight of hand, avoid accounting for her stewardship in an appropriate forum such as the highest court of the land. Our legal team, led by Mr. Chachuchi Kata, put together our case in a clear manner, which left no one in doubt about the issues that were at stake. Apart from seeking to ensure compliance with the Constitution and for the true choice of the people of Ghana to be respected, the petition sought to provide opportunity for transparency and accountability in the management of our electoral process. But no one who followed the proceedings of the Supreme Court will be surprised with the judgment pronounced a few hours ago. Much as I'm aware that we are legally bound by the decision of the highest court of the land, the Supreme Court of Ghana, I disagree with the process of the trial and the ruling of the court. For the avoidance of that, I say, much as I'm aware that we are legally bound by the decisions of the Supreme Court, I disagree with the process of the trial and the ruling of the court. Ladies and gentlemen, our 1992 Constitution says very directly in Article 125, Section 1, that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. I believe that law should not be an instrument for partisan purposes. I also believe that the rule of law should mean one rule for all. What anchors the rule of law is equality and fairness to all, irrespective of creed, background, or political coloration. Justice, we must remember, is rooted in moral foundations. Ghanaians will always remember that moment when my lead counsel, Mr. Chachu Chikata, quoted from the Holy Bible, urging the justices of the Supreme Court to be faithful to their judicial oath and their conscience, only for the lawyer representing the second respondent to argue for the exclusion of God in this matter. And yet in the courts of Ghana, including the Supreme Court, we swear on the Bible or the cross, as we also do with the Holy Quran, to speak the truth and nothing but the truth. Ghanaians will also remember, and this will go into history, this 2021 election petition for that profound moment when the chairperson of the Electoral Commission opted to evade public scrutiny. Everything was done in this trial to prevent the Commission from accounting to the people in whose name they hold office. Requests for interrogatories were dismissed. A request for inspection of documents in the possession of the Commission was turned down. The request for admission of facts was ignored. And worse still, she was aided by her counsel and the court to avoid explaining to the good people of Ghana from her own testimony under oath in a properly constituted court of law the errors that she herself admits to have committed in the declaration of the 2020 presidential election results. This is a clear stab in the heart of transparency and accountability to the sovereign people of Ghana. Whatever the reasons for not allowing Mrs. Jane Mensah to testify or answer any questions, it leaves an embarrassing stain not only on our justice delivery system, but also on our nation's electoral system, which has deepened the grave doubts harbored by many Ghanaians about the true outcome of the December 2020 presidential elections. Ladies and gentlemen, the motto of Ghana's Electoral Commission is transparency, fairness, and integrity. Principles that the key actors of the Electoral Commission clearly failed to live up to on this occasion. The refusal to account to Ghanaians further sets the worrying precedent, and I do really worry about this dangerous precedent that may allow other heads of state institutions to adopt an approach of opacity and non-accountability in their work, just because they know they can rely on unconvincing interpretations of our laws to shield them from scrutiny in the near future when they are held to account. I hope and pray that time will prove me wrong. There's a famous legal maxim brought into common use by Lord Chief Justice Hewart in 1924, that justice must not only be done, but should manifestly and undoubtedly be seen to be done. While judgment was given in this petition, it cannot be said by many to have been seen to be done by the constant unanimous strictures placed on the petitioner in laying out his case. I followed the proceedings of this petition and listened to the testimony of our General Secretary, Johnson Asiedu Nketia, from beginning to end. I'm quite alarmed at the mutilation of his testimony in the Supreme Court ruling. Indeed, the ruling I heard today virtually makes our witness, Johnson Asiedu Nketia, appear like the star witness of the first and second respondents. Many answers of his testimony in cross-examination were taken out of context to create the basis for the dismissal of our election petition. At the appropriate time, the legal team will come out with detailed comments on today's judgment. Ladies and gentlemen, This case will go into the Ghana law reports for the future, and academics and students of law alike will clearly find befuddling the internal contradictions in our jurisprudence. The Supreme Court has given its verdict, but the national debate on the dismal state of our democracy and the increasing weakness of our state institutions has only just begun. It is time we all come together to confront those who seek to destroy the very democratic system that brought them into office. It is our patriotic duty to do so. Ladies and gentlemen, it bears reiterating that our grievances with the conduct of the 2020 elections was not limited to just the presidential elections. Doubts about the Commission's commitment to fairness and transparency have lingered much longer than the duration of this petition. The doubts have attended their every action, and rightly so, because of their posturing and sometimes duplicitous conduct. As I've alluded to in the past, the current leadership of the Commission was installed after the politically motivated removal of the previous Commission. Since then, every step they have taken has appeared to be calculated at ensuring the retention of the appointing authority in power. Aside from the compilation of a new register in the midst of a pandemic, one that many civil society organizations, political and governance experts insist was more procurement-minded than needs-based, the time-tested process of consultation and dialogue among stakeholders through the Inter-Party Advisory Committee was supplanted by unilateralism. This has not boded well for harmonious relationship with stakeholders. Compared to the two previous leaderships of the Commission, what we have now does not meet even the minimum requirement of neutrality and non-partisanship. And these are two essential principles for consolidating our democracy. Today, the much-touted independence of our Electoral Commission exists only in name. This should give all Ghanaians cause for worry. Today, we still have, as a member of the Commission, somebody who publicly stated that the political party which I led into the December 2020 elections is an existential threat to Ghana's democracy. And yet this same Commission member presided over an election in which a party he claimed is an existential threat to Ghana's democracy participated. In the parliamentary elections, clearly NDC won the majority of seats. However, through devious manipulations and connivance by officials of the Electoral Commission, a number of these seats were illegally declared for the MPP. In some instances, the manipulation was so glaring and brazen that a simple intervention by the leadership of the Electoral Commission, as has been done by previous commissioners, could have addressed the issues and righted the wrongs in order to make court actions completely unnecessary. Therefore, it is not surprising that international election observers who attended on the last election identified collation and tallying of results as one of the challenges of our 2020 election. The posture and approach of this current Electoral Commission does not inspire confidence that is needed to preside over any transparent, free, and fair election. Indeed, this Commission has absolutely no reason to continue to remain in office. This is because the Electoral Commission must remain a neutral arbiter and organizer of elections. The Electoral Commission must not have a vested interest in the dubious victory of one party over another. The loyalty of the Electoral Commission must be to the people of Ghana and the Constitution from which it derives its mandate, and not the president or party under whose tenure the leadership is appointed. Immediate reforms reflecting the long-standing image and reputation of our Electoral Commission as one of the finest and most credible on the continent, and indeed in the world, must be one of the focuses of public advocacy if future elections are to be devoid of needless tensions and anxiety. My brothers and sisters, we cannot forget the burning issue of the deliberate exclusion of the good people of Santo Kofi, Akpafu, Likpe, and Lolobi, SAL, from the parliamentary elections of 2020. This constitutes perhaps the gravest injustice of the 2020 elections, perhaps even greater than the election petition. It can easily fit into the worst forms of electoral trickery ever witnessed in our nation's history. Despite the shenanigans employed by the conspirators in this issue, it is abundantly clear that the rights of the people of SAL to vote was intentionally violated as part of a move to ensure the predetermined election outcome of a particular parliamentary constituency. This represents unparalleled abuse of power by both the government and its handmaiden, the Electoral Commission, to influence the outcome of the parliamentary election in that constituency. It is even more staggering that no one has stepped forward to take responsibility for this unjustifiable action, nor indicated any clear remedy for the harm that has been caused the good people of SAL. We cannot, as a people, countenance this kind of gerrymandering and chicanery in our politics. We must with one accord demand immediate resolution of the impasse in the SAL area and take urgent steps to afford the people their right to vote and be represented in Ghana's parliament. My brothers and sisters, we entered the 2020 elections against an incumbent that was determined to abuse power and misuse state resources and institutions to achieve an electoral victory. The run-up to the election and some of the process involved were characterized by intimidation and harassment from state security agents and others loyal to the current regime. Selective deployment of the military was used as a tool to instill fear in some of our citizens to dissuade them from taking part in the voter registration exercise and other processes of the elections. Others were falsely branded as foreigners and their citizenship called into question unjustly. An abhorrent nation-wrecking prejudice which has been directed especially against certain ethnic groups of this country and has continued till date and has only recently been visited crudely on our Auditor General, Daniel Yao Domelevo. In the last election, unprecedented levels of state funds and resources were doled out by the ruling party and unprovoked deadly violence inflicted on our citizens in several circumstances. In the process, 8 of our compatriots were murdered in cold blood, and several others were maimed during the process of the elections. We have designated these compatriots whose blood was shed just because they sought to participate in what is purely a civil exercise as martyrs of democracy, to whom we shall dedicate an appropriate monument when the time comes. I hope we can count on all well-meaning Ghanaians to support our efforts to bring the perpetrators of these murders to justice. Never must a government be allowed to turn the simple process of an election into a bloodbath. Never must impunity of this magnitude be allowed to fester in our democracy. Our independence and the current democracy we enjoy were fought for and attained through the sacrifice and blood of our founding fathers, mothers, and our compatriots. Never must we accept convenience over principle. I take this opportunity to express my deep-seated appreciation to our lawyers, led by the colossus of a legal mind, Chachu Chikata, for a valiant fight which has won the admiration of many. Against considerable odds, they persisted and drove home our point in a manner that convinced all fair-minded observers the just course we had embarked on. I express similar gratitude to all who played diverse roles in putting our case together. I salute our 3 key witnesses, our General Secretary, Johnson Asiedu Nketia, Dr. Michael Pesa-White, and Rojo Metal Nunu for helping to unravel a part of the untold story of the flawed 2020 elections. I also wish to place on record that the services rendered to me by my legal team in this petition was gratis, meaning free of charge. We may not have been successful, but your hard work and sacrifice will not go unheralded when the full story of the 2020 election petition is told. I'm very much aware that there are millions watching and listening to me who are also disappointed at the outcome of this case. For those millions like myself who held out hope that our democracy would be advanced by the process and outcome of this petition, you must be disappointed. But I encourage you to hold your heads up high and channel your disappointment into hard work that will ensure that come the next election, we'll achieve a truly transparent and fair election, which all of us as Ghanaians can be proud of. To all my compatriots and supporters, we may have lost the temporary battle of the 2020 election and the petition that has followed. But the larger struggle to create a society that lives up to our national motto of freedom and justice still rages on. It is a struggle that requires even more commitment than before, and it is one that we will not shirk from until our patriotic aim is achieved. To the millions of NDC supporters who have stood by me, my running mate, Professor Nana Jenopokwa Jimang, our national chairman, our general secretary, our campaign chairman, functional executive committee members, national executive committee members, our parliamentary candidates, our sponsors who were very generous to us during the campaign, and all activists and supporters who gave us their all and all their efforts in the hope that we'll win and form the next government to save our nation and meet your aspirations. I say to you, do not despair at this outcome. And I repeat, do not despair. Never, ever lose hope. We achieved an impressive showing in the last election. And despite the intimidation, the obscene abuse of incumbency advantage, and the massive use of state funds and resources, we can be proud that we gave it our best. Our achievement has become a stepping stone on which the NDC can build to secure victory in the next elections. The NDC will survive and grow from strength to strength. The sun may have set on our hopes for the just ended election today, but it will rise again tomorrow, and it will illuminate our paths to a better outcome the next time round. To the Council of Elders, members of the National Executive Committee of the NDC, the Functional Executive Election 2020 campaign team, my staff, party executives at all levels, volunteers, polling agents, and all who played roles in our campaign, no matter how small, I say I thank you from the bottom of my heart. The NDC will always remain the party of the people. The party was established to empower the people of Ghana to be the architects of their own destiny. We blazed the trail for participatory democracy, and I'm confident that out of the ashes of this legal setback, we will mobilize and rekindle the struggle for a better democratic Ghana. We will be law-abiding, and we will do nothing to compromise the stability of this country. We will, however, continue to be the voice of the voiceless, and will not be distracted from our goal of demanding justice and fairness for the people of Ghana at all times. Neither will we surrender or fail to champion the rights of our people to enjoy the fundamental freedoms guaranteed under our Constitution. To the over 6 million Ghanaians who entrusted me with their votes, I cannot thank you enough for this honor done me. I value your vote so much. It reflects the confidence you have in our ideology, in our ethos, and most importantly, in the 2020 People's Manifesto that we presented to this nation. Our party has proven to be the most viable path to a rapid socio-economic development of our nation. I can assure you that even though this was not the outcome we expected, I'm sure your votes will spur us on to victory in the future. I also wish to acknowledge and commend the courage and commitment of civil society organizations, religious groups, journalists, and individuals who have dedicated their lives to speaking truth to power, irrespective of which individual or party sits at the Flagstaff House. While in office, my administration tolerated your views even when we disagreed with them. In similar vein, we encourage you to continue to hold all governments accountable as you have done in the past, for it is your right to do so. My brothers and sisters, I've had a relatively long and fulfilling journey in public life and service, during which I've had the privilege to serve in various capacities. I've had my ups and downs like all human beings, but I have at all times promoted unity and inclusion and not division wherever I've been. And I've always placed the interest and well-being of Ghana first. I'll continue to do the same even at this moment and beyond. My brothers and sisters, we have only one nation, Ghana, and we must work together to ensure the progress and growth of our dear nation. We can only do this if we ensure equality, freedom, and justice for all our citizens. Long live the NDC, long live Ghana. I thank you all for your kind attention, and may God continue to bless our homeland, Ghana. Thank you very much. God bless you.
Right, so you just heard from the flag bearer of the opposition, NDC, in the 2020 general elections, and also the petitioner in the election 2020 petition, which today has been dismissed at the Supreme Court, John Dramani Mahama. Expressing disagreement about the verdict from the Supreme Court, he says he disagrees with the ruling and also criticizes the decision of the Supreme Court in not allowing chairperson of the Electoral Commission, Jean Mensah, to testify or to be cross-examined by counsel for the petitioners, Chachu Chikata. Now, according to John Dramani Mahama, he says Ghanaians were hoping to hear her testify, and the vital path to the truth was blocked. He says the refusal is in sharp contrast to what Dr. Kwadwo Afari-Gyan did in the 2013 election petition, and he says he disagrees with the judges that this election petition is akin to any civil matter, and so a defendant can choose to either adduce evidence and be cross-examined, decide not to do so, or maybe file for a no defense. He was particularly unhappy with how the justices made the General Secretary of the NDC, Johnson Asiedu Nketia, look like the star witness for the first and second respondents. Well, according to Mr. Mahama, the actions of the Electoral Commission has shown that they cannot be a neutral, Electoral Commission, and certainly they cannot be trusted with organizing the next election. He urges NDC supporters not to despair and not to lose hope, and that their performance in the 2020 elections could be that all-important step in capturing power in the 2024 general elections. This is Upfront. My name is Winston Amwa. When we return after this short break, we're going to be getting into the post-verdict analysis. This evening, we'll be hearing from lawyer Martin Kpebu. We'll also hear from Nana Todazi, a former chief of staff and member of the petitioner's legal team, as they tell us what they make of the verdict and whether maybe the cross-examination of Jean Mensah, chairperson of the Electoral Commission, would have changed anything. All right, so welcome back, and thank you very much for staying with us. Now, we'll be speaking to a member of the petitioner's legal team, Nana Todazi, shortly. But before we speak with him, let's go watch, the Supreme Court, as the president of the panel, who's also the Chief Justice, Justice Kosini Yeboah, delivered the verdict and the concluding statements.
Discretion under Article 296 of the 1992 Constitution by administrative bodies, which includes the first respondent, are not matters for the Supreme Court. These are infractions that the petitioner could have sought redress in the High Court. To quote Mafusam JSC in the Afoko case, Supra, Article 23 of the Constitution deals with administrative actions, and even where a breach of that provision is alleged, the remedy lies in the High Court and not this court. Article 23 is part of Chapter 5 of the 1992 Constitution on Fundamental Human Rights and Freedoms, which by Article 33, 1 and 2 of the Constitution ought to be enforced in the High Court. End of quote. See also Eduse versus Attorney General, 1996-97, Supreme Court of Ghana Law Report, page 1, and Eduse versus Attorney General number 2, 1997-98, Supreme Court of Ghana Law Report 753. On the exercise of discretion under Article 296 and alleged breaches or violations of sin, this court in the Mayor Agblese case, Supra, held per Courti JSC as follows. Throughout the Constitution, discretion has been vested in persons or bodies charged with his responsibility to exercise one power or the other. Where the discretionary power is not exercised according to law, the recourse by an aggrieved party lies in some other remedy provided for in the Constitution, and not an invitation to invoke the original jurisdiction of this court. End of quote. Though the two authorities cited above involve the invocation of the original jurisdiction of this court under Articles 2(1)(b) and 131 of the 1992 Constitution, the same applies to an election petition. The first respondent is an independent body that performs its functions without anybody's directions or assistance. Article 46 is specific about this. It reads, except as provided in this Constitution or any other law not inconsistent with this Constitution, in the performance of its functions, the Electoral Commission shall not be subject to the direction or control of any person or authority. End of quote. We are settled in our minds that the allegation of vote pardon, though serious in an election such as the presidential election, was not proved by credible evidence. Furthermore, even if the vote pardon took place, same was not material or substantial to change the final results, so declared by the chairperson of the first respondent. In holding that the impact of the vote pardon, if even proof, could not have affected the declaration, we are emboldened by the decision of Lord Denny in the case of Morgan versus Simpson, 1975, 1 Queen's Bench 151, which was cited by counsel for the petitioner in his closing address. We observe, however, that counsel for petitioner only referred us to only one of the three propositions articulated by Lord Denny. In that case, Lord Denny summarized the duty of courts in making declarations upon hearing election petitions. He stated three propositions as follows. 1. If the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated, irrespective of whether the result was affected or not. 2. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it did not affect the result of the election. 3. But even though the election was conducted substantially in accordance with the law as to elections, nevertheless, if there was a breach of the rules or a mistake at the polls, and it did affect the results, then the election is vitiated. When Lord Dennis' propositions are read as a whole, the combined effect of the propositions is that an election will be voided upon the occurrence of infractions that actually affect the votes of the citizens cast at the polling stations, and not the incidence of administrative errors and or mistakes committed by officers charged with the conduct of such elections. We find this same sentiment expressed by our own eminent jurist, Adina JSC, in the first presidential election petition case, Akufo-Addo and others versus Mahama and others. Number 4, 2013 Supreme Court of Ghana Law Report, Special Edition, page 733 at page 237 to 237 to 238. Her ladyship had this to say. Quote, courts usually apply the election code to protect, not to defeat the right to vote. Public policy favors salvaging the election and giving effect to the voters' intent, if possible. The right to vote is at the core of our democratic dispensation, a principle I've affirmed in this opinion with reference to the Tenadi and Amma Okansi line of cases. End of quote. Conclusion. We conclude this judgment by emphasizing that the petitioner did not demonstrate in any way how the alleged errors and unilateral corrections made by the first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason to order a rerun as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
As the court pleases.
Conclude this judgment by emphasizing that the petitioner did not demonstrate in any way how the alleged errors and unilateral corrections made by the first respondent affected the validity of the declaration made by the chairperson of the first respondent on the 9th December 2020, as already stated in this judgment. The petitioner has not produced any evidence to rebut the presumption created by the publication of CI 135, for which his action must fail. We have therefore no reason as prayed by the petitioner as in relief F. We accordingly dismiss the petition as having no merit.
As the court pleases.
So that was at the Supreme Court earlier today, where President of the panel and also Chief Justice Kwesi Enin-Yeboah are declaring, that verdict there. Let's get on to Zoom. We have Martin Kpebu, who's a lawyer, joining us. We also have Nana Todazi, who's a member of the petitioner's legal team, joining us on phone. Nana, good evening to you, and good evening to you also, Martin, and thank you very much for joining us this evening on Upfront.
Good evening, Winston.
Great. If you can hear me, Nana, I'd like to start with you, Nana Todazi, because we've heard the petitioner, and in this case, your flag bearer in the 2020 elections, Don Dramani Mahama, speak. He's expressed disappointment, disagreement with the verdict, but it takes a lot of time to also speak against the decision of the court in not allowing Jean Mensah to be cross-examined by counsel of the petitioner, Chachuchi Kata. Now, the court has ruled and the court has said you are supposed to do your case based on its own merit and based on the facts that you provide. How would the cross-examination of Jean Mensah have aided your case? Hello, Nana, can you hear me?
Yes, I'm on. I'm saying that, first of all, I think that the Supreme Court has done a great job, clearing this case in a record time, as opposed to 2013, when we ran some 8 or 9 months. Okay, that's fine. But I'm obviously very disappointed with the ruling today. I think that the court missed an opportunity to make an opening for some intervention, to make an intervention into ensuring that there's a peaceful or even legally clear resolution of the issues at stake. You know, this matter was essentially a question of whether, of figures, you know, whether the figures are right or wrong and whatnot. Now, if the person who has all the figures stays out, no, I mean, that's where the problem begins. I think that's the point. I thought that the court could have even exercised its own discretion, you know, despite you, to exercise its own discretion to have, you know, compel the EC to speak.
Yes, but Nana, the court says you were not able to prove that nobody gained more than 50% of the votes.
Look, this is a civil case. I mean, with all due respect to the later Supreme Court, I'm not contesting their judgment in that sense. I'm entitled to my opinion. But this is a civil case, you know, and you weigh the issues on the balance of probabilities, whatever it is, you know. I mean, a submission of no case in civil cases is really rare. The court would have said so. It's really rare. I mean, in such a competitive situation like this, you don't go straight, you know, I don't think that we should have gone straight with a purely legal, procedural, approach that we did. You get me? That's not to say to sidestep the law, but at least, I mean, our rules of court, the rules governing our practice, you know, make room for the court itself, you know, to call a witness. Indeed, witnesses sitting even outside.
So then what I want to find out is, how would the cross-examination of Jean Mensah have aided your case?
Of course, I mean that's the easiest of the issues. I mean, two people are contesting over a figure or over an issue. There's a third person who is standing by, who holds the answer or the item. What do? You bring that third person in to find out whether A is right or B is right. You see, now I'm saying that unfortunately we have missed, in my view, an opportunity to introduce a regulatory framework that would have enabled, you know, the truth to be found and to settle the issues at stake. You understand? Because the court rightly said that, look, for the administrative arrangements and whatnot, counting the figures and all that, that's purely in the realm, the independence of the Electoral Commission. And they're absolutely right. You get me? But where a dispute arises, you get me, then I think that it is only fair.
And talking about it being fair,
should be brought in.
Talking about being fair, the court says you didn't bring any figures, you didn't bring any pink sheets, and so you were relying on the chairperson's declaration, which, according to the justices.
Well, I don't know whether you put the court on trial, but I have my view. I think I'm
yes, and I'm just asking a very simple question, also because of what you have said, and I'm saying that, and I'm just getting your view on what the court said, and the court says that, look, if you
I'm saying that it's a very straightforward matter. You see, unfortunately, we may have to move a little away from just the law. We don't have a court like in the French system, which oversees the results, you know, at the second tier. After the election, they go up there and then they affirm the what do you call it, the vote or otherwise. You understand? That's one. Then, secondly, here we had, for instance, the eminent advisory team, which I was a member. I called when the issues cropped up. I said that let us, call the parties. Let us find out a way to resolve this issue. You see, when issues crop up, which have potential security implications in the nation, we don't just go to law. You understand? It's not just law.
What is it then?
Has a way of coming out down with sharp edges, and that is a problem. You see, so we must have a conflict resolution mechanism that must be built into our electoral process. And
so in this case, how best
the court come down too sharp, of course, like I'm saying, the Supreme Court, in its wisdom, could probably have said, okay, we throw it back to you. Find a way of looking at the results again. What is wrong? What would have been wrong with that? In Liberia also, that's
But you called, but what you were seeking for was a rerun of the election.
I thought that maybe they could have been innovative. They could have broken new ground for us to move away from the purely legalistic approach to, to find a way of reconciling the issue. And then they can come back with a result. We could have done that. Which the last time we asked when the figures were in issue, they asked an accounting firm to go and reconcile the issue and bring it back. So what was wrong? Why couldn't we do it this time around? That's my problem.
Okay. Kindly hold on, Nana, to that.
Yeah, hold on.
Yes, I'll get back to you shortly. I need to hear from Martin Kwebu also. So,
yes.
Martin, Nana Tudazi says, well, maybe the court could have moved away from the purely legalistic means and probably said, go and resolve it and come back. But the NDC or the petitioner went to court challenging the declaration on the 9th of December, saying based on the EC's own declaration, nobody had 50%. The court has today said, well, if you look at the real valid votes cast, somebody had more than 50%. Would you say that the NDC's over-reliance on that slip let them down?
You see, before you say let them down, I'm not sure that that's the way to put it. That was just one aspect of the case. No, this case, my understanding of it, to be very, very candid with you, from day one, when the case was presented, I didn't see how the NDC, or let's say Mr. Mahama, was going to win the case. Okay? Yes, let's be very clear. I didn't see how it was going to be. So my mind quickly jumped that, okay, maybe I shouldn't be looking at it with only legal eyes. But there's also electoral psychology, the politics of it. So a lot of the time, that's where I've always had my eyes. Because if you look at the petition itself, they basically didn't bring a lot of the kind of evidence that would make one thing that, they were going to win it for sure. You say, I didn't see it. So that's why I said I always understood it to be that, okay, they would want the chief aim of the petition was to ensure that Mrs. Jane Mensah would give an account. Yes, and you see that it turned out to be the pinnacle of their case. But as for really proving to the court that nobody won, it was never in doubt. It was never lost on me that it wasn't clear from the beginning. I was never in doubt that I couldn't see it in the petition. Okay, so look at the other things they sought to gain. And you see the controversy about Mrs. Jane Mensah not taking the stand. So they basically were selling a case of a stolen verdict. And they were lucky that Mrs. Jane Mensah backtracked on coming to give evidence. So it added fuel to the fire, you see. So they've gained something from it. That is the best. That's the way I see it. But not that truly I would see that, this case, they've made a good case that there should be a runoff. I didn't see it.
Let me get Nana to that finally, because our time is almost up. So Nana, Martin makes the point that he didn't see you winning this. Would you agree that you went into this case with also political psychology or election psychology and not necessarily having the rerun? That
No. That's a misconception. Anyone who says that the NDC's Mr. Mahama's position did not represent a case. He was saying that constitutionally, by constitutional ethics, the parties must reach a benchmark. Otherwise, you don't qualify. It's as simple as that. When you are asserting the existence of a legal or constitutional viewpoint, you are saying that it's not the case. So you're saying that what Mr. Mahama at all material times per his pleadings was saying is that the law is that we want the court to affirm that the other party or neither party hit the mark. You see, that is the case. We are calling on the law that apply the law. It's not the evidence that Mr. Muhammad is holding. It's not the figures he's holding.
But Nana, based on the law, the court has ruled that somebody had more than 50%.
Well,
and they say it was clear.
I'm saying that I was responding to your specific issue, you know, or the other person.
Yes, but also, Nana, also talking about constitutionality. Also, you went to court saying that based on the chairperson of the Electoral Commission's own declaration, where she made a mistake and said that total valid vote cast was 13,432,000, and so if we add all of Techiman South to the petitioner, he cannot overturn the more than 50% that the second respondent had. You said based on that, if they added all of it to us, we would have gotten it, and that would have necessitated a rerun of the election.
Sorry, I'm not going to give an answer back. But so what is the figure now? There are such changes. You don't understand?
13,121,111.
Where did you get that one from?
The Supreme Court.
Yeah, I mean, where did the Supreme Court get that one from? The evidence is in the Electoral Commission. They are the what do you call it, the final body. In fact, the returning officer for the presidential election is the what do you call it? Is the issue.
Okay.
No court pronounces any ruling in terms of the vote. The only person who has to do that is the EC.
Okay. Nana, that's all time would allow us. We'll continue with this conversation. We'll have to continue with this conversation. Thank you very much, Nana Todazi. And thank you also, Martin Kwebu, for joining us this evening on Upfront. My name is Winston Amor. Keep watching the JoyNews channel. Do have a lovely evening.